Thanks, Count Corla. And as Count Corla said, the trigger really to table this issue again was the reports in the Sunday papers of the fact that the Coombe Hospital didn't have full insurance prior to 1961, and then the raising of the prospect that because it had carried out a number of symphisiotomies, 14 in fact, in the years between 1950 and 1967, that the hospital itself would have to bear the cost of any claims, and there was sort of frenzied calls of bankruptcy by some of the patient associations. Now, I note that these calls were not repeated by the Minister, and were also not repeated by the survivors either, that the claims of bankruptcy were exaggerated, but the real issue is how do we get justice for the women who were so cruelly butchered in their prime. Now, I'm a bit concerned about where this story came from and where the timing of it is, because it is taking place against the background that you're about to make an announcement relatively soon, Minister, about how you propose to deal with this situation, and you are examining the Murphy report at the moment. Now, what I want to put on the record again is the concern of the survivors that they will not be corralled into any sort of redress scheme. And I don't know if this story about the Coombe, which to be honest is one of the hospitals with the smaller number of women, is just out there to sort of create a climate against the women taking legal action, which I think they're entitled to do. But I think we have to be clear. The damage that was done to these women clearly can't be undone. Some people experienced 25 operations afterwards. They were immobilised at the prime of their life. Children robbed of their mothers in many instances, husbands of their wives, and women living incontinent and in pain, chronic pain for decades. Now, in some ways, this isn't a health issue at all. It should be treated as a justice issue. And I think one of the important points to register is that the survivors have made it clear time and again that they view this matter as one of a personal injury which arose as a result of gross medical negligence. And they need to have an acknowledgement of that fact before there can be any closure on this. And in actual fact, I would say that the O'Keefe judgment handed down in January from the European Court of Human Rights would vindicate their position that the idea of a redress scheme is not adequate to the victims of human rights abuse, which clearly these women are. Now, the women have said that they feel that the idea of any scheme based on a Magdalen Laundry type proposal is unacceptable because it doesn't admit wrongdoing. The levels of restitution fail to reflect the damage that was done to these women. Talk of payments in excess of 50,000 being phased appears like a cynical ploy to hope that the women who are elderly will die out. And no right to appeal, and a denial of their rights to independent legal representation. And actually some of the members of that group have said that type of a scheme would be one of the worst that they're not interested in pursuing. Now, the survivors of symphisiotomy had offered to meet you, Minister, over a year ago to discuss their proposals of what they believe an adequate and acceptable settlement would be, which could deal with more appropriate restitution along the lines of what the courts were offering, but with a haircut to reflect the austere economic times and the fact that legal actions wouldn't be taken. But they also require an individualised assessment, independent medical and legal supports, so that the compensation paid could reflect a range of injuries that was inflicted on them. Now, I would ask you really to reconsider that and agree to meet the survivors of symphisiotomy, negotiate a settlement, because if you impose one, it's only going to result in them going to Irish and European courts to seek justice.
Thank you, Deputy. I now call on Minister Reilly. You have 4 minutes to reply.
Thank you, Clare. Well, just to put in the record of the House that I have met with the survivors of symphisiotomy on a number of occasions over the period that the Deputy alludes to. And secondly, that nobody is coercing anyone into anything. In order to effectively and comprehensively provide indemnity to hospitals and their patients in the event of a medical mishap, the State introduced a clinical indemnity scheme in 2002. This scheme is managed by the State's Claims Agency and provides a robust system for managing eligible claims that arise nationally from that date. Indemnity in respect of claims made relating to incidents occurring prior to the introduction of the Clinical Indemnity Scheme in 2002 is a matter for the individual hospitals concerned and their insurers. The government at the time decided that the clinical indemnity scheme should not apply retrospectively, given that individual hospitals and doctors would have purchased indemnity from insurers on a commercial basis, and insurers had an obligation to fully provide the cover which had been purchased. And I think it's important to remind ourselves of that fact. Insurers have an obligation here. The Master of the Coombe Hospital informed the Secretary-General of my department in April last year that the hospital had issues relating to insurance cover prior to 1961. As this matter has arisen in the context of legal proceedings, the department cannot comment on indemnity obtained by either the hospital or indeed the medical practitioners involved in respect of any individual claims. Indemnity is a complex technical issue, and there is a range of indemnity and insurance arrangements in place for hospitals from before the establishment of the state's clinical indemnity scheme. My department, together with the State Claims Agency, will continue to monitor the position in relation to historical claims against the Coombe Hospital. In relation to symphisiotomy, since coming into office I have endeavoured to satisfactorily facilitate closure for around 250 women affected by symphisiotomy. On the 26th of November 2013, the government approved the appointment of a retired Circuit Court Judge, Yvonne Murphy, to assist in setting out a possible course of action in relation to women who have undergone surgical symphisiotomies. Judge Murphy commenced a review of issues relating to symphisiotomy in December and submitted her report to me in mid-March. I am examining the report and its recommendations, and I intend to bring a memorandum to government in the coming weeks so that a decision can be taken as early as possible regarding next steps. Any proposals brought to government will also take into account the findings of the independent research report on symphisiotomy in Ireland 1944 to 1984, which was commissioned by the department, otherwise known as the Walsh Report, along with any other relevant information. It's also intended that the Walsh Report will be published once the government has decided on its response to this complex and sensitive issue. Thank you.
Thank you, Minister. Deputy Daly, you have 2
I
minutes.
hope I can take the Minister's extra minute as well. Look, at what I was referring to, the survivors of symphisiotomy group specifically requested that you would meet them to discuss their proposals for a settlement of survivors' actions. It's that meeting to which I'm referring, and their needs are that a wrong would be acknowledged, that restitution would be in line with that which was been awarded by the courts. And we should take note that in the Carney case, Mrs Carney was awarded over €300,000, and that was probably a mid-range case. It wasn't one of the more severe cases. Other cases, figures of about 600,000 have been mentioned. Now, the group are prepared to negotiate a haircut on those amounts, but the key stumbling block, and again it's in your report, is there's no acknowledgement of wrongdoing here. There seems to be a sort of, and this is even by your referring to the Walsh Report. The Walsh Report was much criticised for the very reason that it basically said that the practice of symphisiotomy was medically acceptable at a time when it wasn't, and there was no admission of wrongdoing. And there's a belief that a lot of this is framed in order to protect the Institute of Obstetricians and Gynecologists and interests of certain members of that organisation, because if hospitals are insured, well then individual medical practitioners are also so insured, and their personal insurance could presumably be called to account to pay for some of these deaths, for the horrendous cruelty and damage that was inflicted on these women. So I think by a repeat of the arguments that have been rejected by the overwhelming bulk of the survivors just means we're going around in circles on this issue, and I don't think we will have a solution in that regard. So I would ask the Minister, maybe, seeing as you've said you've met the group loads of times, and I know you had, could you take up their invitation of a year ago to sit down and discuss what they're talking about precisely in relation to the legal actions? Because I fear that if that doesn't happen, we're talking about European court cases, going to the United Nations committees and so on, and meanwhile the women are getting older, and some of them have tragically died in the intervening years.